Everyone ready for the 9 o'clock?
Yep. I'm ready.
Okay, good morning, everyone. I'm Commissioner Easterday. I'm going to go ahead and call my 9 o'clock, which is in the matter of Gaurav Kara et al. Versus Rajiv K. Kaura et al. This case number is CB 2023-095174. Let's go ahead and get appearances, please, beginning with, I guess, counsel for the judgment creditors.
Good morning, Your Honor. Dustin Romney here on behalf of judgment creditors.
All right, good morning. And to whom else do we have joining us?
Good morning, Your Honor. I'm Richard Harold, former counsel for the plaintiffs. I just wanted to make sure that, I'm sorry, for the defendants. I just wanted to make sure you did not need me here today because I did receive a calendar invite on this, but I don't think you need me here.
Well, counsel, thank you for being here. I'm not going to tell you how you practice. So I'll let you. Discretion is the better part of valor. I'll let you make that determination whether you need to be here for this application for order to show a cause for a charging order. But good morning.
Okay. I will take my leave then, since our motion for withdrawal was granted. Thank you. Sorry to interrupt.
No need to apologize. And last but certainly not least, Mr. Morning.
Thank you, Your Honor. This is Tom Mooring. I represent one of the defendants, but not a judgment debtor in the case, Ashwani Kaura. So much like Mr. Harold, I'm here in the exercise of discretion. I don't think I have much to add. And unless Mr. Romney feels differently, I don't think he's seeking anything against this Ashwani Kaura. They're all named Kaura, Judge. So against Ashwani, who's not a party to the judgment.
All right. Well, thank you, Mr. Moran, for being here. But let me turn over to Mr. Romney. This is the time set for an order to show cause on your application for order to show cause for a charging order. Mr. Romney, how are you looking to proceed today?
Well, Judge, we'd like the charging order to be entered. We think the statute is quite clear here. We have a valid judgment that has been entered against Mr. Cower and his marital community. He has an interest in the 7 limited liability companies that we've identified. And it doesn't appear that he is here to make any cause or give any argument as to why the order should not be entered. So we would ask that those orders be entered.
And I do have a proposed charging order before me. Unfortunately, due to technical issues, you're gonna have to, I printed it off. I'm gonna have to handwrite in some certain things. So,
Sure.
so today is counsel, on page 3, paragraph 2, there's a line in there for the outstanding interest accrued is $blank. Rather than have me do math, which is always interesting, Mr. Romney, do you have that number off the top of your head?
Well, I'm not sure exactly which number you're looking for, but we have the daily interest on this judgment is $162.10 per day.
Mhm.
And we are at 62 days today since the judgment was entered. So
If you could break that down to third grade math, I think I can do it. You said it's 160, there it is, 162.1. It's on your application, and it's been 60 days, you said?
62 days since the entry of judgment.
All
So
right, so I have 162.1 times 62 comes to $10,050.20.
That's correct.
Okay.
And then we had, and that figure should be added to the 763,442.75.
Right. So the proposed order is as of blank, and I can handwrite in today's date. I can look at a calendar. The outstanding principal balance due under the judgment is $763,442.75, and the outstanding interest accrued is $blank. It's my pop quiz, math quiz for you, Mr. Romney.
Sure. So the underlying principal of the judgment is $750,000.
Okay.
And then there was $12,692.75 in pre-judgment interest, $750 in attorney's fees. And then we're adding to that the 10,050 figure that we calculated for post-judgment interest. So the total judgment that is outstanding with interest, pre-judgment and post-judgment and attorney's fees as of today is $773,492.95.
Well, the blank simply says the outstanding interest, so that's the reason why I was asking for that. And I'm just using proposed form of order.
It's that 10,000.
Okay.
10,000 figure, $10,050 is the outstanding interest.
Okay. Well, I do, based upon my review of the application for a charging order and specifically its attachments, Mr. Romney, thank you for attaching the ACC printoffs. I did cross-reference those printoffs with the limited liabilities companies at issue. I am going to grant counsel's request for the charging order and sign it here today.
Thank you, Your Honor.
Is there anything else we got to do today, gentlemen?
Not from my perspective, Judge. Thank you.
Mr. Moynihan?
No, sir.
All right, well, if there's nothing else, then this matter is adjourned. Have a good rest of your Tuesday and try and stay cool out there. It's going to be another scorcher.
Thank you.
Thanks,
You as
Judge.
well, Judge.
All right, good morning. It's 9:15, so let's go ahead and call the next matter, which is in the matter of the Secretary of Housing and Urban Development versus Rod Braddock et al. This case number is CB 2026-014863. Can I get appearances, please?
Yes, good morning, Your Honor. Kristen McDonald on behalf of Plaintiff, Secretary of Housing and Urban Development.
Good morning, Ms. McDonald, and it looks like you're the only one appearing in this matter. Everyone else is either my staff or the recorder. So how would you like to proceed today?
I am requesting the court enter default judgment in favor of my client.
Ms. McDonald, I do not see, the last thing I see is my order. Well, I see the notice of lodging, but I also see the order granting alt service, but I don't see the certificate of service.
The certificate of service was hand filed, I believe, over the counter and may not have hit the docket yet. I do have, it's the court stamped copy I just pulled from our process server. So I do see that it was filed. But I did also check the ECR and noted that it was not on there. We'll note that the copies of the order granting alternative service, the minute entry dated August 6, 2026, the summons with the complaint and exhibits A through B and the civil cover sheet were served in accordance with the order for alternative service by posting a copy for each of the parties, the defendants, on August 20th at 7:10 p.m. in a conspicuous place on the property. Thereafter, our process server mailed via certified mail, return receipt requested, and first-class mail postage prepaid copies of the documents to the person to be served at the place where the copies were left on August 20th, 2026.
And do you have a digital copy you can send to the division, or is just have the paper copy?
I have a digital copy I could send.
Do you mind? Well, thank you, Miguel. You read my mind. The division email is in the chat if you want to use that email.
Okay.
While Ms. McDonald, you have appeared before me a number of times, I just like to just have the paper copy in there because I just want to lock eyes on it is what I'm trying to do.
I completely understand.
But while we wait for the speed of light to catch up and that to hit the division email, why don't you run through why you're entitled to the default judgment you're seeking? After you hit send, obviously. I'm not going to ask you to. That's just too early to do all that stuff this morning.
No, I've only had half a cup of coffee. Let's see. 1 moment.
I'm sorry, Miss McDonald.
Okay, I just hit send on that.
Thank you. Sorry about that again.
No, I apologize.
You're not the one that should be apologizing. I'm not the one that's making you do all this stuff.
No, it's understandable. We want a clean record. So this is an action for forcible entry and detainer following a foreclosure sale. The plaintiff purchased the subject property at a foreclosure sale held on November 5th, 2024. On November 12th, 2024, a commissioner's deed upon sale was recorded transferring the property to plaintiff, and a copy of that commissioner's deed is attached as Exhibit A to the complaint. A notice to vacate the property was sent to the former owner of the property on February 24th, 2026 via regular and certified mail. Return receipt requested, providing 14 days to vacate the property. Defendant Rod Braddock signed the green card on that notice to vacate. Upon information, I believe it's our understanding that the former owner of the property is now deceased, and appears Rod Braddock now occupies the subject property. The defendant has failed to vacate the property, and following the notice to vacate, and this instant complaint was filed on April 6, 2026. Service was effectuated on August 20th, 2026 in accordance with the court's order for alternative service. And I'm requesting the court enter judgment in favor of plaintiff with a writ to issue on or after August 31st, 2026. And we are not asking for any fees or costs.
You read my mind about my next question, because I do see a proposed form of judgment before me, because I do see that the notice of lodging, I see that in docket. It's weird how things are not, I wouldn't say real time, but it's weird how this lag occurs. So basically just asking for possession with writ of restitution, 6 calendar days. Is that correct?
That's correct, Your Honor.
Okay. Well, based upon counsel's avowal and reading the certificate of service. Oh, I hear a staple. Miguel, Miguel? Right on time. Thank you. So Miguel has handed, my judicial assistant has just handed me the certificate of service stamped August 24th, 2026, showing showing posted and mailing service on August 20th, 2026 at 7:10 p.m. in a conspicuous place. So based upon everything before me, I do find the defendants to be in default. The summons and complaint were proper and timely under 13A1 of the Arizona Rules of Procedure for Eviction Actions. I also find, based upon, I think it's that green card, specifically Exhibit B, show to the complaint shows proper termination notice was given. So 13A2 has been met. Based upon the trustee sale, I do find that the plaintiff has a superior right of possession, so 13A3 has been satisfied. This is neither a partial payment case nor is this a subsidized rental, so A4 and A5 of Bill 13 are applicable. So based upon everything before me, I do find in favor of the plaintiff, and I will issue the judgment as has been proposed here to me today. So thank you, counsel. Sorry about making you jump through all those hoops this morning, but again, trust but verify. I'm glad I got to lock eyes on the certificate of service. So,
Absolutely, yes.
anything else we got to talk about today?
Nothing from me, Your Honor. Thank you.
Well, thank you. If there's nothing else, this matter is adjourned. Have a good rest of your day, okay?
Thank you. You too.
Bye.
Bye-bye.
Aquí se va a ver, se oye.
Ahí está, sí.
Good morning. It's 9:30, so let's go ahead and call number 3 on my calendar, which is in the matter of R.E. Ranch LLC versus Rosa M. Flores et al. This case number is CB 2026-033055. Can I get appearances, please, beginning with counsel for the plaintiff?
Scott Williams for the plaintiffs. Give you standard of balance. Good morning.
Good morning, Mr. Williams. And I see we have, whom else do we have joining us here today?
My name is Rosa Flores, and it's my son.
Hello, I'm Asserted Flores. I am not on this. I'm just here to help my mom emotionally.
Okay. Well, good morning, Ms. Flores. I'm going to ask that you please raise your right hand because my clerk is going to swear you in, okay? So just go ahead and raise your right hand.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
You have to, okay. All right, thank you. Go ahead and put your arm down now. So this is the time set for initial appearance on an eviction action. Ms. Flores, just kind of give you a quick overview of what this hearing is going to cover is I'm going to ask Mr. Williams to state and summarize the material allegations of his complaint. And then when he's done, well, when he's talking, I'm going to ask that you listen carefully, because when he's done, I'm going to turn it over to you and ask whether how you plead and if you contest anything. And I may ask you some questions based upon what you tell me, okay? And then I'm going to make a determination about how to move forward with the case, whether. I'll make a determination after that. Okay, so Mr. Williams, why don't you go ahead and take it away?
Yes, Your Honor. We're indicating a trustee's sale took place on April 7th of this year. RE Ranch LLC. Let me take a look if they were the purchaser at the sale. It looks like they were, and we're seeking possession. And notice was dispatched on July 24th to the defendant, demanding possession of the premises attached to the complaint. The fair rental value is indicated at $24.49 pursuant to the attachment of the fair market rental value evaluation or analysis report. So that would have 5 months at $24.49. We're seeking $12,245. Court cost of $552.61, being the filing fee $367 and $175 for service, and attorney's fees of $1,500. Total request today $14,297.61. Sometimes there's a little difference there because of turbo court fees, but I think that's basically what we're showing at this time. Thank you.
Thank you, Mr. Williams. Ms. Flores, how do you plead? You responsible or not responsible? And if you contest anything, what do you contest?
Yeah, I'm not responsible, my honor. And the thing is, like, when she got the house, when she bought the house, it was April the 2nd. I got the paper when she sent, give me that. She said that the sale was it's on foreclosure audit with public. And then later on, she sent the one that he was saying, the 7. Like they trespass from her when she buy it, another person, I think. But when she get the house, she was here at home, and she was telling me that she was gonna be the new owner, and I was really upset because that morning, AC Homes called me about 9 in the morning asking me to take the money for the payment. I was doing the payments, and then I told him that I couldn't go because my mom is sick. My mom is 85 years old, and I'm taking care of her. And I asked him if he can give me 2 more hours, and he never responds. Okay. And then she arrives, and she's telling me that she's the new owner of my house. And I said, okay. And then she asked me if I want to sell the house, if I want to buy the house. And I told her, yeah, because I'm here with my mom, and I can buy the house. When we submit the first contract of sale, it was the title company didn't want to close it because they found alerts. And then she sent me a paper. The name of the lady is Monica Carranza for the paper and for the title. And then well, she was upset, but the thing is, like, we got an agree that we're gonna do a FHA loan, and then it takes like 3 months before the sale to get a FHA loan. And I told her, instead of be 435 that she was telling me, it's gonna be 445. That way she can keep the 3 months when we close the loan. She's gonna have the money. It's gonna be I raise the price. That way she's gonna get it for the 3 months of rent. I'm not, I mean, like, I didn't have money in the moment, and the person who's gonna buy the house, he's already qualified, and we're supposed to be closed in 1 more week. But when she did the first contract of sale, the lady from the title, they keep the money. They was giving some earnest money. Now she wants again $1,000 earnest money, and I asked her if she can please lower or just wait until we finish. Because, well, I'm not working right now, and then I just got my last stroke in October, and I'm just taking care of my mom and my son. So I asked her, what I can do, I can ask Frank if he can pay a little bit more for the house for this month of and he was agreed. Frank is my friend. I'm not applying for the loan because I'm not working since I got my first stroke 2018.
Well, Ms. Flores, you kept saying she. Who is she when you were?
Rita Pizarro. Rita Pizarro is the lady. She's investor and she works with AC Homes and other companies. She works a lot with them. But I think when Rita sent me the proof of the insurance about the property, underneath of that email, I saw a thank you from Rob Lincoln and Jeff and Greg Jewell, the owners of the AC Homes. They tell them thank you for buying the house, and we're gonna give you 50,000 a credit or your loan, any loan.
When did AC Homes send you that information?
When she sent me, it was then April 8th or April 10th. Is when she sent me the insurance from my house. And then at the bottom of that, the first email was from Rob Blanket saying to the insurance guy, hey, this is gonna be a flip. This is gonna be a flip on this address.
Okay, so do you contest that the property went to trustees public auction on April 2nd, 2026?
Yes. That's what she says. She got it in April 2nd, 2026.
So you disagree that the home was sold at a trustee's sale on April 2nd?
Well, no, did you disagree that? No, she showed me there was on the sale the April 7th, but the lawyer was saying the sale was in April 7th, and it was in April 2nd.
Okay, so in April of this year, 2026, you agree
Yes.
that the home was sold at a trustee sale?
Yes, that's what she says. Yes.
Okay.
But the thing is, like, when I asked, I'm sorry, can I say something? When I asked AC Homes and the title company for the breakdown of the sale, the breakdown, how much money, they didn't give me any answer. AC Homes was saying us the title, and the title was saying me as the AC Homes, and the thing is, like, AC Homes, they manipulate the loans, the terms on the loans, and I have emails from Randy, from this lady, telling me that when we close the loan, how much payments they already have in money, and how many payments I need to do to be fine. And I did the 2 payments that she was behind, and then 15 days later, she told me I was behind December. Like, she called me in March 30th, asking me for 2 payments to be good. And then I go in April 7 or 12, I went and paid the $5,200, and then I did insurance for the house. And then she later, like in 1 week, she told me it was from December. I was late from December again.
Okay,
And
so you were late on your mortgage payments.
well, what happened is, like, I wasn't.
Ms. Flores, it's a yes or no question. You were late on your mortgage payments, is that correct?
Yes, I was late on April.
Okay,
Yeah, in March.
you were late, and then the home was sold, the property was sold at a trustee sale in April of this year, correct?
Yeah, that was yes. Correct.
Okay.
But the loan was under me. It was under my name. Wait. No, sorry.
No, that's okay. Anything else you wish to tell me, Ms. Flores?
Yes, I just want to tell you that we just got an agreement when I get the house on the money they're supposed to be paid. I increased the price of the house. That way she can have the money. So I don't know why she have me this. And then she knows that I just have 2 strokes. I got nervous, and my English is not good, and she's still like, I don't know.
Thank you, Ms. Flores. Mr. Williams, any reply?
I saw an email from the defendant, I think just came in, I don't know, last night or today, and I'm trying to catch up just before this case to get an idea. As I understand it, since April, she's been working to try and purchase the property back using a friend of hers named Frank for financing. If I understand it correct, that's kind of the summary of it.
Okay. All right. Well, it doesn't change the facts that, Ms. Flores, I want to thank you for being here. Mr. Williams, thank you for being here. Based upon what I've heard today, I have reviewed the complaint for forcible detainer. Ms. Flores, I listened very carefully to what you had to tell me, okay? But at this time, I do not find a triable issue. So based upon everything before me, I do find that under Rule 13A1, the service of the summons and complaint were proper and timely, and the complaint complied with Rule 5 of the Arizona Rules of Procedure for Eviction Action. Under A2, I do find the tenant had a proper termination notice that is specifically Exhibit A to the complaint. That was not mentioned during Ms. Flores' statements to the court. Based upon the trustee's sale that occurred in April of this year, that is Exhibit B, the trustee's deed upon sale, I do find the plaintiff has a superior right of possession. So I do find 13A3 has been satisfied. This is neither a partial payment case nor is this a subsidized rental under A4 and A5 of Rule 13 of the Arizona Rules of Procedure for Eviction Action. So therefore, based upon this court's determination, I do find the defendant to be responsible for forcible detainer. Based upon everything before me, I do find plaintiff's request to be appropriate, so I will enter the judgment here today. Mr. Williams, is there anything else we need to talk about from your perspective?
No, Your Honor. She'd be able to continue her conversation with Ms. Pizarro with regards to purchasing the property.
Ms. Flores, anything else you wish to tell the court?
No, thank you.
All right, thank you. If there's nothing else, then this matter is adjourned. I hope everyone has a good rest of their day, okay? Thank you.
Thank you.
Take care.
Thank you. Thank you.
All right, good morning. It's 10 o'clock, so let's go ahead and call in the matter of Absolute Resolutions Investments LLC versus Brian Mendoza, case number CB 2025-031568. Can I get appearances, please, beginning with counsel for the plaintiff? Mr. Frattoni, if you are counsel for the plaintiff on behalf of Gerstel Law Firm, your mic is muted.
Got it. Thanks, Your Honor. Sam Frantoni with Gerstel Law Firm for the plaintiff.
Good morning, counsel. Let the record reflect no one else is appearing. There's no one waiting in my virtual lobby, and this matter was set for 10 o'clock pursuant to my minute entry that I issued back on July 21st. So, counsel, I originally had this hearing set. Well, this matter came as some certain packet before me in the first part of this year. I had questions, so I set a hearing. No one appeared on behalf of plaintiff's counsel. I set it on the dismissal calendar. No action was taken. Matter was dismissed. It looks like you filed, or someone in your firm filed a motion to reinstate. I granted it and set the hearings. I wanted to again talk about the issue about attorney's fees. And then I see, as of August 13th, 2026, you filed a new application for affidavit and entry of default under Rule 55A, resetting the clock for when the defendant can file an answer or other defensive filings. Is that your reflection of the procedural history of this matter, sir?
Yes, that's exactly right.
All right. Well, then I think because the oh, there's someone calling in. All right, good morning. I'm Commissioner Easterday. I just admitted a phone number ending in 2276. To whom do we have? Phone number 2276. To whom do we have? Please announce your presence.
Thanks, Your Honor. This is Brian Mendoza.
All right, good morning, Mr. Mendoza. I called the case right at 10 o'clock. So why don't you go ahead and raise your right hand and let us know when it's raised, because my clerk's going to swear you in.
Yes, sir. My hand is raised.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I swear.
All right, thank you. So you're going to put your arm down now. So, Mr. Mendoza, to get you caught up, again, I called the case right at 10 because, the case was set for 10 o'clock. Mr. Counsel for the plaintiff is present. I then ran through the procedural history that how I set a hearing earlier this year to talk about attorney's fees. Plaintiff's counsel failed to appear for that matter, for that hearing. Put it on the dismissal calendar. No action was taken by the plaintiff, so this matter was then dismissed. Plaintiffs then moved to reinstate the matter. I granted it. Also set the hearing because, again, I wanted to talk about the attorney's fees issues, and that was a minute entry that set today's hearing. But then since then, plaintiff has filed a new application for an affidavit for entry default on August 13th. and we were, and that's when you sought to join the virtual courtroom. Okay, sir.
I understand, sir. I apologize for being late. I was on the phone with your assistant.
Well, because there's a new application for entry affidavit of default, the 10 business days hasn't run, so I'm thinking about just vacating today's hearing. But I wanted to, because there's really nothing for me to do, because there's really nothing for me as a commissioner who handles defaults to do. So, counsel, what are your thoughts?
Yeah, obviously we sent out the default notice, and the defendant has time to do what he has to do in response to that. So I'm okay with just proceeding on that action right now, and I'm fine with vacating today's hearing.
Mr. Mendoza, what are your thoughts on vacating today's hearing? Because again, there's really nothing for me to do based upon the recently filed application for an affidavit on entry of default under Rule 55A.
To be honest with you, Your Honor, I'm not really sure what that means. I'm not so I'm assuming vacating means continuing this at a later time, or
well, I'm sorry, Mr. Mendoza. Vacate today's hearing would mean to just kind of conclude today's hearing without really taking any action or doing anything, and not setting any future hearing dates at this time.
okay. And what is this affidavit about? The default judgment? What does that exactly mean?
Well, I can't give you legal advice, Mr. Mendoza, but I will say on the record, I pulled up on August 13, 2026, Plaintiff's Counsel filed a new application for an affidavit on entry of default, seeking to, and that was on August 13th, and that's under, okay.
Yes, sir. I'm seeing that right now on the records.
So, Mr. Mendoza, any other questions? Anything else you wish to talk about today?
About resolving things with Absolute Resolutions LLC. Do I just contact them on my own time?
Well, again, I can't give you legal advice, but if you want to reach out to their counsel, Mr. Frattoni, and again, if I mispronounced your name, please forgive me, sir. But perhaps you can reach out to counsel who's here and to discuss resolution.
Hey, counsel, do you mind shooting over an email to me, or perhaps giving me a call later on?
No, I don't mind calling you. I can give you my direct phone number as well if you like.
That'd be very much appreciated. Thank you, sir.
Are you ready to write it down?
Yes, sir.
480-420 2265. So that's 480-420-2265. My email address is S like Sam, F like Frank, at Gerstel.com. GURSTEL.com. And let me just verify that I have your information. I've got your first name, last name, 1736 at iCloud.com for an email address.
Yes, sir. That is my email address.
And what's the best phone number for you, sir?
It's going to be 623-271-2276.
And it's okay for me to call you later today?
Yes, sir. I'm available after 3 p.m.
Okay. And just to
And also
confirm, you're still
available-
at six. Go ahead.
Go ahead.
You're still at
I'm also-
1667 West Boulder?
Oh, no. I reached out to one of the people from your office and I updated this. So my address is 20588 South Ellsworth Loop Road, Queen Creek, Arizona, 85142.
85142?
Yes, sir. 85142.
Oh, okay. And again, 20588. What's the rest of that?
South Ellsworth
South.
with two
Okay.
L's. Loop
Is there apartment number
Road,
there or?
1132.
All right. Very good. Thank you.
Yes, sir. All right, that's all I have. Your Honor, I know this doesn't matter probably, but on the website it says that I'm a female. I am not a female or male.
On the
That's the
website.
court's website?
Like the Maricopa, like where I can see all my records and stuff. It says I'm a female, but I'm not.
I don't know. Well, Mr. Mendoza, I don't have control over that. I don't even know where you're looking.
Oh, I'm sorry. I was just looking at the Maricopa County like case lookup.
May I suggest that that Mr. Mendoza contact the clerk's office to try to straighten that out?
Okay, yeah, that's not really something that I can find and B, really do anything about, Mr. Mendoza.
No worries. I was just mentioning it, Your Honor.
Yeah, but
Well, thank y'all for your time.
well, thank you. Anything else from either party,
Nothing from me. Thank you.
Mr. Mendoza?
Nothing from me either, sir. Yeah, I mean, Your Honor.
All right, well, thank you. If there's nothing else, this matter is adjourned. Have a good rest of your day, everyone, okay?
Thank you.
You too, Your Honor.
right, good morning. It is 11 o'clock, so let's go ahead and call number 5 on my calendar, which is in the matter of State Farm Bank FSB versus Bruce T. Griffin et al. This case number is CB 2012-008854. May I get your appearance to, can I get you to introduce yourself by saying your name, sir?
Good morning, Judge. I'm Bruce T. Griffin, and my wife is here also, Cheryl A. Griffin, who was named in the request.
Well, good morning, Mr. Griffin. Before we proceed any further, I'm going to ask that you please raise your right hand because my clerk is going to swear you in, okay?
Okay.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. You can go put your arm down now.
Thank you.
All right, so this is the time set for oral argument on your motion filed back on May 14. Sorry, this is taking a lot longer than I would even want, but here we are. So please do accept the court's apologies about not intentionally dragging this out, but just the way things worked.
Sure.
Your renewed motion to compel satisfaction of judgment from State Farm Bank FSB. Is that your understanding as well?
That is correct, Your Honor.
All right. I do not see a response from your May 14, 2026 motion from any sets of counsel, whether it's from State Farm Bank or its successors in interest. Do you also?
I'm sorry, there was no response.
Okay. Well, Mr. Griffin, I had to diagram this to figure out. So if I understand correctly, State Farm Bank FSB no longer in business, or if it is, its successor in interest became this CompuShare holding. Can you run through because then we got New Res and ShellPoint and all these DBAs, and I started diagramming it and my notes became super messy. And it sounds like I'm just going to ask you, since you're the moving party, who is State Farm Bank's, the judgment creditor's successor in interest?
Well, it went to the first party that you just named. They in turn merged with or sold the book of claims, I guess, whatever they had from State Farm Bank, and ShellPoint became the person of record or the company of record to administer this judgment claim. And then ShellPoint merged with New Res, and they became the company of record where it all ended.
Okay. But in one of your exhibits, specifically attachment 3, there is a 1099-C for tax year 2023 from CompuShare Holdings, Inc., doing business as Specialized Loan Servicing LLC, which you've in your motion characterized as SLS, correct?
Correct.
So when CompuShare Holdings had the judgment debt, it canceled your debt. Is that your understanding?
By issuance of the 1099-C, that canceled the debt, and then to go further, they, between the time they canceled it and the time that the release of lien and trust was issued by ShellPoint in a letter and a recorded document. So there was another transition between the 1099-C and that release document.
And based upon the 1099-C cancellation of debt for tax year 2023, looks like that according to the 1099-C, the date of identifiable event was November 28th of 2023, and then MEB Loan Trust by New Res LLC. Man, you just gotta love these names. Doing business as ShellPoint, released the judgment, and that was recorded June 27th of 2024. Is that what your records show, Mr. Griffin?
That is correct. It's what I have copies of.
And then I see numerous letters from you and Mrs. Griffin and emails asking for your satisfaction of judgment to be filed in this CV number, correct?
That's correct, with your court.
And based upon your case law of AmTrust Bank versus Fawcett, specifically paragraph 1, the Court of Appeals held, we hold that while issuance of a Form 1099-C may be prima facie evidence of cancellation of debt, the lender may rebut the evidence by showing that when it issued the form, it did not intend to forgive the obligation. But I have no evidence from State Farm Bank or its successors showing that 1099-C was an error or didn't mean or just didn't mean to do it. So, Mr. Griffin, while I have you here, did you receive anything from any of State Farm Bank's successors? I'm not going to name them all. That said that nope, we didn't mean to issue that 1099-C or release of lien. We goofed. Anything of that nature that you received?
I received nothing from anybody, from any of the State Farm Bank successors, the original law firm that they had hired. And therefore, I think that's when that next letter was written, releasing the lien and deed of trust, corresponding to verify that 1099-C, is what I understand.
Okay. Well, anything else you want to argue or tell me, Mr. Griffin, in light of this?
You know, all we're really trying to do here is once that was released, Shell Point or New Res, according to what I could see, had 40 days to file with your court that everything was taken care of. And that's when we went back and forth with them. I think they basically, after they wrote the letter, they just washed their hands of it. They didn't want anything else to do with it. And that's all we wanted. We just wanted the letter to show that in the docket that the situation was resolved. And it went back and forth a lot of paperwork, but nobody would ever reply. The last services came back unavailable. That's kind of where we're at. We would just like a minute entry showing that the situation is resolved and not enforceable.
Well, I mean, you're not wrong with under Arizona Revised Statute 12-1567 subsection A, quote, the prevailing party shall file a satisfaction judgment in the Superior Court within 40 days after a judgment has been paid in full, end quote. So, also, I mean, you filed a motion to compel satisfaction of judgment based upon what is before me, the unresponded to renewed motion that you filed back on May 14. No one appearing, I mean, you appearing, Mr. Griffin, but no one from State Farm Bank or any of its successors or successor in interests or counsel for any of the above appearing here today at today's argument. And I do find that that 1099-C and the release of judgments, that's all good prima facie evidence that they meant that this judgment has been satisfied. So I'm going to grant your motion, Mr. Griffin.
Well, thank you, Judge.
And Drew, please have today's minute entry specifically find that I grant the motion to compel the satisfaction of judgment and a specific order that the judgment is deemed satisfied. So this the minute entry that's going to be generated for today's hearing should state specifically and emphatically the judgment is deemed satisfied. Also, based upon my findings, I would like Drew, please add, and I'm talking to my clerk, so we're gonna we're talking about the minute entry here. Drew, also please add my e-signature to the minute entry. That way, if anyone hops up, that adds a little more gravitas, and it does make it an appealable order. So that puts any State Farm or any of its successors in interest on the clock to appeal my decision. Okay.
Yes, will do.
Mr. Griffin, did any explanation or any questions about what I'm doing? There is a method to my madness, but
That covers my wife as well as the adjoining
Yes, it does. I'm granting the motion.
Okay,
And as far as I'm concerned, you have demonstrated, based upon your motion and its many attachments and your under oath statements here today, that there is prima facie evidence that the unrebutted prima facie evidence of the debt being canceled. So based upon 12-15-67, I'm granting your motion and the judgment is deemed satisfied as far as I'm concerned.
thank you, Your Honor.
Well, thank you. Again, sorry it's taken a little bit longer than I even wanted to hear this matter, but hopefully you don't walk away too disappointed with your government and the Superior Court.
I'm very happy. I was getting a little tired of answering questions to creditors. You still got a judgment out there, and I say, I really don't, but hopefully I can get that handled. So,
Well, hopefully this makes your life and your wife's life a little bit easier moving forward. But,
thank you so much.
You're welcome. Any questions, anything else we got to discuss about this matter?
Not with me.
Well, you're the only one here, so if there's nothing else with you, then this matter is adjourned, and go enjoy the rest of your Tuesday, okay?
Well, thank you. I just may do that. You too.
Awesome. All right, thank you. Bye-bye now.
Thanks. Bye.